Hello, dear students. I, Enaniya, Assistant Professor from Government Law College, Ajmer, welcome you to our channel. And today we shall be studying the Right to Information Act. We will try to understand Section 24 of the Right to Information Act, which mentions or specifically excludes the scope and ambit of this act to the security organizations and the intelligence agencies established by the central government. And the list of such intelligence agencies and security organizations are provided under second schedule. Okay, so the second schedule only mentions about the intelligence agencies and the security organizations created by the central government, which are excluded from the scope and ambit of the Right to Information Act, and any information which is provided by such intelligence agencies and security organizations to the government are excluded from the applicability of the Right to Information Act. The Right to Information Act is not applicable to these intelligence agencies and security organizations, which are at present a total of 18 as provided under the second schedule. But there is an exception to it. Okay, and the exception here is in the form of proviso. There are two provisos here, and they provide two grounds, and by virtue of these two grounds, okay, so these are two grounds which are, if there is an allegation of any human rights violation, firstly, and the second is if there is an allegation of corruption within the activities of such intelligence agencies or security organization, because here the public money is involved. That is why here this is made as an exception. Okay, so the proviso excludes from the scope and ambit of this section 24 on the basis of two grounds. Okay, so on the basis of human rights violation or corruption, such intelligence agencies and organizations whose list is provided under second schedule are excluded here. And again, such information can be sought by any applicant. Okay, and the information will have to be made available under the Right to Information Act. And here the second proviso provides another condition, that is the Central Information Commission permission is required, first of all, to seek information under the Right to Information Act on the ground of any allegation of human rights violation or corruption. And if it provides its nod, thereafter the information will be made available. But here section 7's time limit will not apply, and the time limit is provided under section 24 itself, which is a time span of 45 days. Next subsection provides that the second schedule can be amended by the central government. So the central government is more than competent to amend by way of addition or by way of omission. So if it under its discretion, if finds that the name of any security organization or any intelligence agencies be added to the second schedule, then it may be added. Or if under its discretion decides to omit the name of any pre-existing intelligence agency and organization, then it can do so, and it shall amend the second schedule. And it can be done by a notification in the official gazette. So, if such a notification is made, then such amendment shall be laid down before each of the houses of the parliament. Okay, so the parliament has to approve it. Thereafter, this act shall also, the next subsection, this act shall also not be applicable to any security organization or intelligence agency created by the state government. Okay, so the Right to Information Act is not applicable to such intelligence agencies and security organization as are created by the state government. Okay, but there is another again two provisos attached to this subsection, and they provide the two grounds. On the basis of these two grounds, the Right to Information Act again is applicable, and the grounds are if there is an allegation of human rights violation, or if there is an allegation of corruption in such organization, then the information will have to be provided. But the next proviso provides further condition, which is the nod, that is the assent of the state information commission has to be obtained priorly. Okay, and if its assent is given to provide the information, then it will be provided within a time span of 45 days. Again, here the time limit as prescribed under section 7 is not applicable. Rather, the time limit as mentioned under the section 24 itself is applicable. The state government may from time to time amend the names of the security organizations and the intelligence agencies, and thereafter, by way of addition or omission, it can add or remove the name of intelligence agencies and security organizations from the scope and ambit of this act. So, if the state government, under its discretion, wishes to add the name of any intelligence agency or security organization from the scope of or the ambit of the Right to Information Act, then it can do so. Or if the state government, under its discretion, wishes to bring in any security organization or intelligence agency within the scope and ambit of the Right to Information Act, it is free to do so. So, the state government can accordingly do the work, okay, by notification in the official gazette. And such amendment and of the names of security organizations or intelligence agencies will have to be laid down before each houses of the state legislature. Okay, I think it is clear to you people that intelligence and the reason for exclusion or omission of such intelligence agencies and security organizations is because the nation's security is involved here. Okay, a nation might be required to do some intelligence work or counter intelligence work, okay, in order to maintain its sovereignty. Okay, so in order to prevent any terrorist activity or any unlawful activity which might arise, or any destabilization which might be tried to be caused by any other foreign government. So or if any kind of any disharmony is tried to be spread, or if any such planning is being done, then in order to protect the sovereignty and in order to uphold the unity and integrity of the nation, the working of such intelligence agency or security organization is very important and very crucial. That is why the such security organizations and intelligence agencies are excluded from the scope and ambit of Right to Information Act, because they are required to protect and uphold the democracy and its ideals and the republic. Okay, so thank you, dear students and viewers, for listening so patiently and carefully, and we shall meet again. So have a great day ahead. Thank you.